see she's on here. I don't see the picture, but that's okay. All right, Josh, you with us?
Yep.
Okay, well, let's call the meeting to order then. It's 1:02. Let me make a note of that. Okay, first up on the agenda is the approval of the agenda, which Josh doesn't have it up there, but the agenda is simply, okay, there we have it. There was a late edition, so to speak, of the agenda that review of resolution M09 and the registration form drafts. Otherwise, the agenda is, well, was originally distributed as any comments, amendments to it before we continue on?
Motion to approve.
Okay. Bob's moved to approve. Is there a second?
Second.
Okay, we got a motion to approve and second. Say all in favor, aye.
Aye.
Any opposed or any extensions? Okay. It's approved. Let me make a note there. Okay, the minutes of the meeting of January 21st. Just a brief mention that was in when I distributed these materials. I didn't attempt to make an extensive description of the minutes of the meeting. It was essentially a review of our proposals as they were contained in the bylaws proposal document, with our review with our liaison to proceed forward with actual proposals before the special committee, a special meeting of the board of directors. So what I have done is attached to what you see here is the bylaws proposal document and the bylaws summary document updated to what we did at that January 21st meeting. I don't think we need to scroll through it, but with that explanatory comment, do we have any additions or deletions or other comments with regard to the minutes of the last meeting?
I read through all 26 pages. I don't see any need for changes.
Okay, you're
I'll
glad.
make a motion to approve.
Okay, that's good. Okay, was the motion would come from Bob today? Was that you, Bob?
Yes.
Yes.
And it was Laura was second, right?
Yes.
Okay. All right, we have a motion to approve and a second to that motion. Any further discussion? Okay, all in favor again, say aye, please. Aye.
Aye.
Any opposed? Any abstentions? Okay, it's called 4-0. Okay, next item on the agenda now is public comments, and I don't see anybody on here who would be considered public comment. So I'll continue on past that. All right, the first item on the agenda of unfinished business is to review the Board of Directors bylaws proposals. I believe that, Josh, you can put up those proposals as we go through them.
Yes.
Okay, if you want to start with the first one, and let's go from there. Okay, this particular proposal is one that came from this committee, and it deals with the definition or adding a definition of eligible to vote. And the background simply is that the term's used throughout the bylaws in several places, and it was thought desirable at least to make a specific definition of it. So do we have any? The proposal is basically as we recommended it. Do we have any further comments that we need to make on that? Okay,
I see no need for any additional comments.
Okay. Okay, if we have any, don't have any further comment, then let's continue on from there to the next one, Josh. Okay, here again is a proposal that came from our committee. And it was a revision to the first sentence of paragraph 3.03C. And again, it pertains to the eligible to vote reference. I want to say why I look at 303C. Okay, it originally read that determine the member's eligibility to vote, and this just changes it to eligible to vote to correspond with the definition that we just discussed. So again, this is simply the way we are our input. Let's put it that way. So we have any further comments or explanations or whatever that may be necessary.
Looks good to me.
Okay, let's go on to the next one. Should be 305. Again, this is another one that we had proposed, and it's the same thing as the preceding proposed resolution. It deals with consistently putting in wording that means eligible to vote, not something like eligibility to vote. It's same thing as the prior one that we looked at, 303C. So again, it's the same thing that we put in. So we have an additional comment that we want to make on that. Okay, I'm going to keep going here.
Yep.
What's up next, Josh? He and I have not gone through this, rehearsed this, so we'll see whether we got the same one in the same order.
Yep.
Okay, this is 404B. All right, this merits some comment, Colette, in particular. What's missing here is there's actually an additional subsection 404C that should be added to this. I don't want to, Josh, I don't want to put you necessarily back and forth, try to put you back and forth. The intention of this proposal is to bring forward to the bylaws what is in the charter regarding sending out notices. And the charter was revised back in 2013, among other things, that included a provision in it that we would send only a single notice to the membership where there is a situation in which we have more than one member or one owner member in the deed to the property. In particular, that applies where there are owners of different addresses. And the intention is that we would not be sending out, expressed in the charter, that we would not be sending out notice to member owner A who lived at XYZ in Glen Burnie, Maryland, owner B who lived in Laurel, Maryland, and member C who lived in Frederick, Maryland, for example. It would only go to one member, and it was intended, it would be addressed to in such manner as it would go to the attention of all members. That's what's in the charter. It was never brought forward to the bylaws because for one reason or another, it wasn't thought really necessary. But we are now in the bylaws amendment process, and it's appropriate to bring this forward to the bylaws as part of the notice provisions in the bylaws. So Colette, what's missing is a proposed subsection 4.04C, which would read, a single notice addressed to indicate it is to all members in common of the subject property shall be sent to the address designated above. That's designated in the B above. It is the responsibility of the recipient to forward such notice as necessary to other members who hold property in common with the recipient. Required notices to members shall be sent without regard to eligibility to vote. Somehow that got missed. I think partly it got missed because I forgot to forward that information to you.
I believe, Jim, that was in this summary document that
It
I
is.
used to write the motions that I wrote. And that was my error. I neglected to include that paragraph C. I believe you brought this to our attention during the special meeting at which these were discussed. And we agreed as a board to amend the motion regarding this bylaws change to add that paragraph. That paragraph since has been added, and it should be in the packet that with the other bylaws, or I'm sorry, they didn't go into the packet. They went on the website as a reference for members to review in preparation for the public hearing. And so I have taken care of that.
Okay, the copy I've been using, I copied from the website in the last couple of days. I haven't been back on the website since then. Let's put it that way.
So it wasn't there.
A couple of days ago, it wasn't there, but now
Okay, let me double check that and make sure that I am referencing the correct bylaw. I think that was the only one where I had left off a paragraph C, and I did send to Linda the amended motion to
Okay, well,
include on the website. So I'll make sure that that shows up on the website. Thanks for bringing that to my attention.
okay, we're all in agreement, I think. Any of the committee members have any further comment on this?
Can I ask just a quick question? This obviously applies to multiple owners of a single property in Ocean Pines who may have other addresses.
That's right.
My question goes to, do we need to address, and I don't know the answer to this, so do we need to address the issue of the same owners of multiple properties in Ocean Pines? In other words, Joe Blow and his wife Mary own, a house at, 1 Ocean Pines Road, and they own another house at 52 Ocean Pines Road. Does that, in that scenario, does the notice requirement, is it covered, or does it need to be covered or addressed in some other fashion?
I currently own multiple properties, and I receive one notice for each property at the mailing address I designated. So I think that would answer the question.
Okay, that's fine. I just didn't know the answer to that. Okay, thank you.
Yeah, I think we would probably have difficulty going any other, in other words, try to send one notice to a person or persons who have multiple properties. That would get, if we tried to do something, it'd probably get very confusing or subject to problems, particularly when it comes to sending out voting materials. At any rate, I think we all understand where we are on this one. And I think, is there any further comments or discussion before we continue on? Okay, let's keep on going here. What's up next on your list, Josh? Okay, this one is the special meetings. Again, this is another one that we put in. Okay, the our part of what we were trying to accomplish here is that this reference, this provision refers to section 4.07C3. This has to do with petitions. In the current 4.03, it refers to a 15% vote, 15% signature requirement for calling a special meeting by requested by the membership. The 407.3 also included the 15% number or reference. All this did was delete the 15% and just refer to the requirement in 407.3, which is where you would get the actual petition number or signatures required. But it's just a consistency kind of thing, not have the same information twice in different places of the bylaws. Okay. Any comments on it? Again, it's exactly what we had in our own proposals. Okay, if not, Josh, let's keep going to the next one. Sooner or later, he and I are going to have different ones, but we'll see what happens. Okay, this one's one of our proposals where we discussed how to make reference to reference documents in the bylaws, so that we didn't have obsolete references or references that were inaccurate kind of situation. And this is, again, is one of our proposals that how to word the reference to some source outside of the bylaws, and the end of the proposal where it says and limits established in the financial policy and financial procedures manuals. That's a general reference as opposed to any specific reference to a document or a document name that may become obsolete over time. Any comments on this one? Okay, again, it's the same as what we put in. Next one up. Okay, this again is another one from our proposals on the same subject, referring to, in this case, personnel policies and procedures, I believe it. Yeah, personnel policies and procedures, rather than the current bylaws have some reference to personnel manual or some such thing like that. And that kind of thing is taken out of this and made somewhat more general. One comment I will make, there's a typo in this one. If you go down to the next to the last line and where it says programs wages schedule, I think that should be wage schedules.
Yeah.
You okay with that? Yep.
Okay, I will get that corrected.
Okay. That, obviously a minor item, but while we're at it, try to keep it somewhat well in its appearance. Okay, anything else we want to comment on this one? Again, it's out of our proposals what we made. Okay, let's go on to the next one. Okay, this is 4.07 petitions. This one, this one, we had two changes that we asked, or actually it's three. Two of the changes had to do with the wording of eligibility to vote or eligible to vote. In this particular subsection, eligible to vote appeared twice, and one of the eligible to votes was taken out. I haven't marked my copy to indicate where, but one of the eligible to votes was taken out. And we also ended one of the sentences to accomplish that. The other change that was made is at the end, pretty much the last sentence. It reads, "The Secretary shall certify in writing to the Board of Directors that the petition meets the requirements of the bylaws." It did not specifically direct the Secretary to file with a certification to the Board of Directors. It just simply says, currently says that the Secretary shall certify. The change that's in here directs the certification to be to the Board of Directors, so it becomes effectively a formal manner of record. And there is a later proposal that kind of ties in with this, but those are the two proposals that we made. One removed a eligible to vote reference, so that there was no duplication in this section, and the other added this certification to the Board of Directors. Again, it's as we proposed. Anybody have any comments that wish to make on that? Okay, let's keep going. Up next. Okay, what's up next is the issue of what is meant by maximum number of votes regarding the number of signatures required on a petition. What is here is the Frank Daly proposal on this particular issue, but it's amended. It was amended at the meeting a couple of weeks ago to add to each of these 1, 2, and 3, where it says as referenced in section 3.01A. 3.01A is that part of the bylaws that identifies how you determine where what are the voting lots in the association, and that's something that we had wanted and put in our proposal, that we referred back to that section so that we effectively closed the loop on being able to identify the source of determining the number of votes within the association. So this is the wording of the resolution with that added reference is basically the same thing, that different words, yes, but basically the same thing as we proposed in combination with what Frank Daly proposed. Hopefully I explained that well enough. Is there any questions or comments on that? Okay, again, it's basically same as our proposal in our documents. Okay, next up, please, Josh. Okay, there is some comments, and Colette, I do think this is a case of where I did not communicate something back when you were not in the meeting at that time, our meeting of January 21st. This again is the proposal to amend how a referendum reaches the approval status or approval state. The changes that were made at our January 21st meeting, starting out, I'll just read along. Any proposal presented in a standalone referendum, we deleted standalone so that it would read any proposal presented in a referendum. Then continuing on, our proposal properly reads, must receive a minimum of total votes cast for for or against, I'm sorry, for and against.
Right.
I've got this wrong here. Okay,
It had originally said for or against.
yeah,
And
okay.
at the meeting, you had suggested the correction to make it for and against, and I did make that correction.
Okay, and I see the corrections in here. I'm sorry,
Yeah.
I've got an old copy, but I believe we also wanted to delete the standalone, so it applied to any referendum.
Okay,
Committee members, correct me if I'm wrong in that.
No, I agree with you.
okay, so that changes the motion. And so I'm gonna have to go back to my board colleagues. And, I'm gonna assume that they will approve changing, amending this motion, on, I think since it's a document that will be on the web rather than something that we had mailed to the membership, we're okay making that change. And we'll need to make sure that Jeremy Tucker has that correct wording as well. So I'll follow up on that.
Okay, and
If I may add, by taking out the standalone reference in 408C, it then becomes consistent with the language in 408D, because D does not have the standalone reference.
Right. Thank you.
whatever procedure the board goes through, to a significant degree, this can be considered our committee comments applicable to the public hearing. Whatever process the board wants to go with comments that come out of here, that's not our business. I'm just commenting.
Okay.
But anyway, that is call it a recommendation, if nothing else, from the committee at this point. Let's put it that way.
Yeah, the question I have, if you go down to the background, unless you make that change, it's inconsistent with the background. If you can slide down or raise that thing up to the bottom. Yeah, the background, where we're justifying the reason for it, 1% could change it. If you went down to the bottom and said it didn't apply, if it were part of an annual election, then what difference would it make? If you had a minimum, it means if you sent it out with the normal balloting and there were no requirements, then the justification for saying 1% of the voters could change it is negated.
Okay, I'm not sure I follow that, Bob.
Okay, here it's saying real reason. Theoretically, it would permit as little as 1% of eligible voting members to decide a referendum, correct?
Yes.
Okay.
Now, if you go down to the bottom and say the requirement would not apply to resolutions that are conducted at the annual election of directors, that means that 1% could change it if you had a small turnout. If it were not consistent with any time you want to change a referendum.
Okay, well, removing the standalone.
If you remove the standalone, then it becomes consistent, because down at the bottom, you're saying the requirement would not apply to referendums that are conducted with the annual election of directors. So
That
Right.
that doesn't belong in there now.
I know.
Right. So standalone needs to be deleted both places. I think it's
Yeah.
what Bob is saying.
Yes.
There's also a typo, by the way, in the background.
Yeah, that 40% rather than the
Oh,
number.
right.
40,
Yeah.
yeah.
Okay.
Yeah.
That's a simple fix. But yeah, the other one, just when I read it, that's what stood out to me.
Okay.
Yeah, well,
Right.
thanks for reading all the way through and catching that.
I never saw the $40.
Yeah,
Okay.
I read all of them the other evening. That was the one that really stuck out.
Okay, are we straight on this one now? standalone comes out in at least two places. Let's put it that way.
Yes.
Okay, what's next, Josh? Okay, this is the duties. This is the tie-in again to a partial, at least tie-in to the part where the secretary would now have to certify in writing, I believe it said, to the board of directors that there's a valid petition. This just simply says that when the board gets the certification of valid petition from the secretary, they have 60 days to consider that petition. There's perhaps in the current bylaws, perhaps a little bit vague. It just says that the board has 60 days to consider the petition. I'm not sure that somebody couldn't try to interpret that to mean, well, reconsider the secretary's rejection of the ballot. We don't in anywhere in the bylaws say anything about what the board would do with regard to a rejection. That it's left at the secretary's responsibility, and to continue on from some appeal from that would have to be determined how to proceed with that with regard to the how the board would proceed with that kind of a situation. We only deal with the board having a requirement to consider a valid petition within 60 days. Any comments on this one? Okay, Josh, let's keep going. All right, now I'm not sure that the last 24 hours or so I have been on the website. The last time I was on the website, this appears twice on the website.
Okay.
Okay. Do we have any comments on there's two parts here. One is a new definition, 1.11, owner of record, and the other is a section 5.01 modification or amendment. Let's start with the 1.11 owner of record. Does anybody have any comments on this one?
Give me a second here, will you?
It's a significant difference. I shouldn't say significant difference. It is a significant difference. It is a first time definition of owner of record. There is no such definition in the governing documents at this time.
I have a question, I guess I want to direct to Colette if I can.
Yes.
Colette, I tried to watch a fair chunk of your special board meeting. I may have missed this one. The discussion in this, or the language in this motion relating to corporation, limited liability, partnership, etc. Was there any discussion at any time about just barring? I'm sorry, this has to do with owner of record, not eligibility. I take it back. I won't ask the question. I apologize.
Okay.
Let me ask another question though. Was there any discussion about including the SDAT database other than the land records of Worcester County?
No.
Okay.
Is this committee advising us to consider that at this juncture?
Well, my recollection, and that's all it is that when some of the different proposals that we made, more in the eligibility question than in this, dealt with the fact that the SDAT database is a lot more accessible, easier to access, I should say, for the secretary or anybody else doing the sort of checks that would be required. Whereas the land records of Worcester County, to the best of my knowledge, are not computerized at all. If you want to see the land records, you have to go down to Snow Hill to see them. And at least in one of the drafts that I know I did, was we put in an and/or reference. And I never, again, I'm doing this by memory, but my recollection is that was never picked up in the other resolutions in the eligibility requirement either. So on the other hand, this may require a substantive change to these various motions. But my view at the time, and I don't know that this had a lot of discussion, but my view at the time was that if we were committed to the idea of addressing the various issues that came up in the FAR litigation in light of the judge's decision, a simple review of the SDAT records might well have short-circuited the controversy. But again, I don't know the reason why it's not in there, and it's more in the terms of a question than anything else.
Yes, and you may know the answer to this question. Do the SDAT records faithfully correspond to the Worcester County land records?
To the best of my knowledge, my answer would be yes. But from my prior employment, it was always a lot easier just to get online and go through the SDAT records, at least initially, to do some checking for whatever reason. You know, I don't know as to the more populous counties, Anne Arundel, Howard, Montgomery. I don't know how computerized those records are, but I can tell you that for them, well, sometimes it's cumbersome to get in there. The SDAT records are just more easily to access. But there may be a reason why they're not included. For argument's sake, they may not be considered to be official records of the county, even though they may well be the official records of the state. I don't know. But it just seemed to me the issue was, you know, within the short time frame that exists from the filing of and again, this does go to eligibility more than this issue, but in the short time frame that exists between filing of the application and the certification by the secretary to the election committee, that being able to get online to go through SDAT records might be the quickest way to do it. It may not be fail-safe, but it would be the quickest.
Right, and so if your committee is wanting this, as I said, this was not discussed by the board. I will take this to the board for discussion and consideration. I think it would be a substantive change in the content of that revision. But I don't believe that would preclude us from amending this motion. But again, I'd have to go back to my colleagues, and if you would like me to do that, I will.
Okay.
I would agree that it's a substantive change. I agree with that.
Okay. I have a couple of comments. One, the Worcester County land records are accessible on the website, and I believe all of the county records are as well. On a couple of occasions, I've gone outside of the Worcester County search on the website, and I can't vouch for all counties in Baltimore City being accessible through the Maryland Land Records website, but the Worcester County land records are certainly on the website. I have difficulty with the Department of Assessments and Taxation website being used, and this also is also referenced in the M09 draft that we'll get to later on. Excuse me. The reason why feel that way. And Colette, I think you were the secretary at the time. There was a candidate who perhaps was in question with regard to eligibility because SDAT records showed what was actually his parents with a life estate. Now, that going to the deed itself on the land records would not have answered the question itself. I think it turns out that the parents were in fact deceased, so that, and that he had been granted a life estate subject to that. I mean, not a life estate, fee simple. The applicant had been granted a fee simple interest in the property subject to his parents' life estate, and both had previously predeceased the application. Going to the land records would not have precluded that question, but it gives you more information. And I don't know to the extent, again, in the recent FAR situation, to the extent to which that reference in the SDA, the reference of ownership in the SDAT records led to an erroneous conclusion. If you had gone to the land records, if one had gone to the land records, it would have been clear that there was a trust situation existing. Whatever the outcome may have been regarding that, there still would have been a clarity as to what the land ownership, more of a clarity as to what the land ownership circumstances were. So I'm reluctant to bring the SDAT into the bylaws. And again, when we get to the M09, we got the same situation. We say either or kind of thing.
Yeah, and Jim, I think you raise a valid point that the transfer of ownership is not automatic on the death of the trustee. If it's a beneficiary trustee situation, the ownership transfers only when the deed is recorded in the county records, the county land records, is my understanding. Now, I'm not a lawyer, but that's what we were told. And we were waiting for that, transfer of ownership to be recorded to be able to certify Mr. Farr as a director.
Okay.
So I think, I'll take it back to the board, but I do think that the language in this motion creates, it's a more conservative approach and a more careful approach to ensuring that the ownership is accurately reflected. Now, it wouldn't have solved all of the problems with the FAR situation, because what created the confusion was not the presence of a trust, but the confusion came from not having put legal name on the application itself. And so the assumption was that the Richard L. Farr, whose name was on the SDAT records and the land records, was what we later found out was Richard D. Farr, the applicant for the board candidacy. So, but at any rate, your committee maybe wants to vote on whether you want me to take this back to the board or leave it rest.
Well, if I can, based upon Jim's indication, I candidly was not aware that the Worcester County land records were online in any fashion. I had not been able to secure that. I had actually gone back to SDAT on a couple of occasions to check some other things, but if my view had always been, and the reason why I put it in that way was because of the compressed time frame by which the secretary had to act between receipt of the appropriate applications for candidacy and the certification. So if the Worcester County land records are online and easily accessible, I don't have a problem with leaving this language as is.
Okay,
I was more focused on not to say the records were inaccurate, but at least to give the secretary the opportunity to refer to one or the other within that time frame.
Steve, not to get off on a tangent. In your search engine, I tried putting in Maryland land records and see what kind of selections you come up with. You will probably find that you have to sort of become a member of whatever. You have to put an email address in and maybe even a password. I don't remember now. On my computer is set so that I click on something and it comes up.
Okay, I'll do that. I had only gone over to the Worcester County government. Never saw anything that suggested that it was.
Yeah, there is a Maryland land records website.
Okay.
Okay. Okay. Do I understand that we're going to leave this as is with regard to the property reference in the owner of record definition? Okay, I have one further comment before we go on to the next item on this. Does anybody else have an owner of record comment? Okay, I'm just simply going to say that I made public comments at the special meeting when the board considered this definition, and I expressed my opposition to what I call representative capacity, eligibility to be a member of the board through whatever it says here, officer of a corporation, living person who's a member of the LLC, or living person who is a partner in a partnership. I do not support that provision, or that part of the provision. I believe that this is a homeowners association, and that the members who have responsibility for the management of the association should be those who are personally connected through contractual requirements through the DRs, committed to the rights and obligations themselves in person. And that's my comment, and I'll leave it that.
is this something that your committee would like to vote on with respect to my taking forward to the board that objection? I think you raise a valid point, Jim. I agree with you.
Okay, I'm going to leave that up to discussion of the committee. If somebody, go ahead and discuss to whatever degree you want to, and if we get to some point in time where a motion should be made or could be made, someone go ahead and do it. I'm not going to participate further or participate in any motion. Let's put it that way.
Well, Jim, can I ask you a question before you fully abstain?
Okay.
My understanding of what you just stated as your comment during the special board meeting, if I'm wrong, tell me, but my understanding, this provision identifies a particular person who would be listed as the owner of record. As to the eligibility question, my recollection is that we included in the language we forwarded basically a ban on corporations, LLCs, partnerships, etc., from being eligible to run for the board or to sit on the board. And the underlying supposition was that you remove a potential conflict of interest between what is in the best interest of the association and the members of the association and that person who is, at least in part, the owner of the property within Ocean Pines, that is the corporation or the business entity. and I guess I would draw a distinction between identifying for the purposes of either voting or providing notice or whatever as the owner of record and eligibility to serve on the board. And I'm trying to, I didn't quite grasp whether or not you were suggesting that the eligibility question is the one that needs to be addressed.
Yeah.
Yes, I'm trying to hesitate here to make sure I've got my thoughts in order. Number one, I agree with the expression conflict of interest, although I have not used that. I agree with that expression in what we're talking about. With regard to eligibility, well, number one, yes, without me getting our proposal document back out, I remember that part of it with regard to, I believe, eligibility. And in another document, which I'm not sure that was ever distributed to the committee, my personal approach was to have a much shorter definition of owner of record, which would have ended with the most of the underlying part at the top would have been the definition, not going any further than that. And I would have dealt with eligibility considerations separately, which is basically, I think, the same kind of thing that you're referring to. The issue, not issue, the situation we have now is this is what we have. The eligibility parts do not address what you are referring to, and which was in our earlier proposals.
Yeah,
How it is addressed is a consideration. Yes, I understand that.
my recollection of our earlier discussion as a committee was, and correct me if I'm wrong, your view was owner of record should essentially say member in good standing. That is, you paid your assessments and your interest and whatever other requirements might exist. And then the eligibility question would have been as we submitted it under 502A, I believe, a series of steps where a particular candidate might be ineligible. In other words, you hadn't paid your assessments, you were you were a candidate beyond the second consecutive term, you had a family relationship, those sort of things that we went through last time. But you were comfortable, as again, this is my recollection, by saying member in good standing, and then the other restrictions under 502A would apply to eligibility. I think we're sort of saying the same thing, we're just saying them differently.
I agree, we are.
Okay. Well, if that's the case, then I mean, I would move that the committee position be restated to the board. That is, owner of interest should be limited to that issue and eligibility should be separated out in some way.
I agree with what you're saying. That's exactly what we discussed.
I can go along with that.
Okay, and, I would say that I put those motions forward to the board and they were, I guess, superseded by what Frank and Jeremy put forth, which is this and the other motion. So I can go back to the board. I'd have to go back and we'd have to rewrite motions. We'd have to rescind 2 motions and rewrite motions to address the owner of record issue separately from eligibility. And so let me take that back to the board and see if,
Okay, well,
you haven't voted on it, but
No,
it sounds like that's where you're leaning.
Yeah,
So
we
vote.
need
do your bidding.
Steve, can you, kind of on the fly, can you try to, I'll transcribe it if you can give me a motion.
Uh,
Sorry.
That's right. Oh, let me put my glasses back on so I can read what's in front of me here. Um,
What we want to do is separate the, who is an owner from what ownership is eligible to be on the board.
right, and I would think of course, before I do that, Colette, may I just ask you a quick question? And
Sure.
I missed this when I was online watching the special board meeting. Was there any discussion among the board members and Jeremy about the provisions that we submitted dealing with corporate entities being barred from eligibility to serve on the board? Recall.
In the meeting, I can't remember, I'd have to go back and look at the tape, but we did discuss corporate entities. But I don't recall the exact content of that discussion.
Yeah.
You know,
Okay.
this motion, my understanding is that this motion came out, this was Jeremy's recommendation that we couple owner of record definition with the qualifications to be a director.
Right.
And that is
right.
not how, obviously, that's not how you had intended to address it. That's not how I intended, you know, reflecting what you guys gave me. I had decoupled these, and there was a separate motion for definition of owner of record 1.11. And then there was another motion under, you know, I think one of the issues that came up in the FAR litigation is that the qualifications to be a director are different from the qualifications to run to be a director. And Jeremy wanted to correct that, as did Frank. And I think that's what this was an effort to do. They coupled owner of record with service eligibility to serve, which also couples it with eligibility to run.
Okay.
And that, you know, I agree with you guys. I think the more rational way to do it would be to decouple those. But, you know, I got overruled. You got overruled. We could take it back, and I think you put forth a very rational argument. You know, and I can certainly call Jeremy and discuss this with him personally. But again, then we have a matter of how are we going to address this for the public hearing. And my understanding is that the public hearing would not be expected to result in substantive changes to the referendum questions, but merely to put forth, you know, the opportunity for discussion with the board on the changes and for the public to hear their fellow members' perspectives on whether they supported these questions.
Understood.
So
Could we scroll up a little bit? There's at the bottom of this page, it says section 502A, and I can't, because of the bar, I can't read what's below that. There you go. Hold on. Yeah. Jim, I'm doing this on the fly, but my suggestion would be that in the reference to 1.11 owner of record, that it that all after the period in that first sentence which ends subdivision to which votes are attributable period could be deleted, and owner of record means yeah, take that out, and then you would have to, hold on. Owner of record means the person listed on the deed recorded in the land records of Worcester County as the owner of property, grantee / property in second part, within the subdivision to which votes are attributable, and is a member of good standing. And I think you could pick up the language in 502A, which referenced section 303, whatever that was. I can't see it. No, don't take it out. Just scroll up a little bit. Yeah, 301C, which I assume deals with the assessments. Is that correct?
Yes.
Yes.
Yeah, I would think you could, I think what we're saying is if the owner of record is the person who's listed on the deed and is up to date and paying their assessments.
Well, that, you're coupling together again a definition issue, which is what 1.11 is, with an eligibility to run issue, which is a 502A issue. And I think that's what I didn't like about this motion, is that I think definitions should be definitions. And then the other parts of the bylaws may reference a definition, but the definition is standalone. And so I think how the definition got written the way this motion writes it is the issue of trustee versus beneficiary trustee. And so that is addressed in this trustee and co-trustee issue. And then the judge brought up the issue of LLCs and other corporate entities and was not pleased with the fact that we did not have clarity in our bylaws, nor did we have clarity among, the secretaries and the lawyer about whether a corporate entity could be, which owns a piece of property, could be a candidate. So I think defining ownership belongs one place and in one motion. I think defining eligibility to sit as a director belongs where it belongs, which is 501.1. And then eligibility to run belongs in 502A, where it currently resides. I felt that this motion muddied that terribly.
Yeah.
Well, I think I agree with what you're saying, Colette. Maybe I didn't explain it correctly. My suggestion is that in the paragraph which says section 1.11 owner of record.
Yes.
If you after the word attributable, strike the period and just insert and is a member in good standing as provided for in section 301C, which I believe only deals with your assessments are up to date along with any interest payments, and delete the rest of it. So the owner record is the much shorter definition. All of the eligibility follow below that in 502.
But Steve, you can own property whether your assessments are up to date or not.
Right.
And 1.11 is about who is considered an owner of record, not whether they paid their assessments. Payment of assessments belongs elsewhere, 502A, perhaps 501, in terms of eligibility to sit on the board, or, you know what I mean? So I think that referencing that in the definition muddies that water, that there are plenty of people who don't have their assessments up to date because they're on payment plans, perhaps, and they're still owners of record. They're still legitimate owners, but they just have certain restriction on their rights as owners by virtue of criteria that are set forth in other places in our bylaws. So I think that the definition kind of, maybe is fine, the 1.11 but again, I shouldn't even be speaking because it's your committee. It's what you want. And I'll take fourth, whatever, but I'm just saying, I'm not sure that approach is gonna fly with
Okay,
the
let me-
board, and I'm not sure it solves the problem that you guys are grappling with here.
Okay, let me jump in here despite my disavowal. There were comments about the 301C reference. That's part of eligibility as far as I'm concerned. I think what we're heading toward is a recommendation or a motion, whatever, that would take this current 1.11 owner of record, limit owner of record to what Steve has indicated, ends at the second line, which votes are attributable, period. And that's where the owner of record definition ends. Then the remainder of what's there belongs in 502A, I believe it is. It belongs consideration as part of eligibility to be a candidate or on the board of directors itself. That's where it looks to me like we may be headed as far as a motion. Again, I want to
Okay.
back out here.
So what we're essentially saying is, based upon what you just said, Jim, is the owner of record is any person, or for that matter, any corporate entity, because it follows, as listed in the Worcester County records, the land records of Worcester County. That's what we're saying.
And trust owner, you're saying.
Right, because they would be listed as the trust.
Well, hang on a second. It's not said here, but I think this is my personal view and my personal viewpoint, opinion. There is a definition of person or persons, whichever, in the real property article of the Maryland Code, and that definition includes individuals, which I understand to be a living person or natural person, and then it lists corporations, partnerships, trustees, other entities, whatever. It's an all-encompassing, persons is an all-encompassing definition in the real property section of real property article of the Maryland Code. And there's also sort of a companion definition applicable to corporations in the corporations article. What we're talking about here, though, is real property, and persons is defined. And I think I would hope that there doesn't have to be a qualifier added in here that says persons as defined in article such and such of the code. But persons is a defined term, which would include trustees, partnerships, corporations, LLCs, and virtually any other entity, as the definition goes.
So
Yeah.
we would just leave it at the attributable period, leave it at that.
Yeah.
Anything else would be.
Yeah, leave it at that. And then the rest of the current definition shown here would belong, in our opinion, recommendation, whatever, would belongs in the consideration of eligibility for both board membership and candidacy. In other words, to cover a situation of appointment,
Right.
as well as election.
Right.
Say eligibility for board as well as candidacy.
Right. Yeah, I would be fine with that.
Okay, how,
I'm not sure the board's going to accept it.
Board may not agree, but I think there's a big difference in eligibility, who's eligible to run and serve as a board member. And if it's a corporation, as opposed to an individual property owner, I disagree with that. I'd certainly vote against it as a member of that.
Yeah, and Bob, you raise a good point in that, the goal is to have bylaws changes that improve our bylaws and will be clear and supportable by the membership. And that's the problem I think we have with this motion, is that this unless Jeremy cleans up the language in the referendum question, which he may indeed do, to put all of this into one referendum question is a recipe for failure, I believe.
Colette, I've been kind of hesitant to say this, but this definition, and again, even if you separate it out as we've been talking about, could have a house of cards effect on what happens if this proposal as written and even as separated, if it fails, you go back to what we have now.
Right. Yeah. So I think, again, I think you guys raise valid points. I would like these points to, I don't know how you want to proceed with delivering to me what you would like to deliver to the board with respect to this. But I think this is what the board needs to hear, in simple form, if it can be simplified.
Well, if I could just point, I mean, I understand the argument, and to some degree, I agree just with the political atmosphere, if you will, that when you read the different blogs and all, that Jim is correct. I mean, we could have a house of cards where everything just collapses. I understand that.
Exactly. Yeah.
And that was, again, I'm sort of new I'm probably the newest resident of the Pines among our members here, but it seems to me that was, once you opened up this whole area of examination as to eligibility and who's an owner of record and all of the related issues that came up during the FAR litigation, you were always running that risk. But the view, and again, I think I'm correct about this, the view of this committee was always, or has been at least since we started kicking these issues around, is that there's a distinction between being a member of the association and being eligible to serve on the board.
Yes.
If assuming the committee still believes that to be the case, then I think Jim's suggestion about how to deal with this section and the related eligibility questions makes sense. But I don't disagree. The atmospherics are what they are. That's just not going to go away based upon what I've seen online. So.
Okay. Laura, you have any comments?
No, I agree with everything that you're saying. Generally, I agree in making any of these motions, they shouldn't be muddied. We want our fellow residents and owners to be able to read this and be able to agree on the whole portion of it, because if we put in things that they might agree with the first part but not the second part, I think then you run the risk of people just saying, well, no, then I can't vote for it at all, and then that defeats some of the work we've done. So streamlining some of this, especially this one, in separating out your definitions, I think it's a good thing. But I would agree with your suggestions on how to shorten this and separate and move parts of it.
Yeah, and Jim, I will just add, you were present when we discussed this in the meeting, as was Bob, I believe. And Mr. Farr is the one who wanted the co-trustee added. So I think, as the litigant, that's important to him. And I think what you had suggested earlier about referencing the Comar real property definition of a person maybe makes this a simple definition that anybody could understand and that covers all the bases. And then we separately put these other qualifiers in that have to do with the eligibility. to run and eligibility to serve.
Okay.
So that's, again, it's your committee, it's your recommendation, but that's my thought sitting
Okay,
here as a director.
Okay, kind of two steps here. Am I correct by saying that we are in agreement on ending the definition at the second line after the words "which votes are attributable," and then recommending that the remainder of this section or this recommended definition be placed in elsewhere in the bylaws to cover eligibility, where it would be covered as eligibility to be a candidate for the board of directors or a member of the board of directors. Is that a reasonably close to accurate statement as to where we are right now, at least our consensus?
Yes,
Yes.
for me.
Yeah, to make it very clear, a corporation is not eligible to run for the board.
Okay, hang on there. Let's not go there yet. That's where I'm going to get to next. All right, so we're recommending again that we take out everything beyond the second line, that everything beyond the second line be covered as eligibility and to be a candidate and eligibility to be on the board, not try to write provisions into the bylaws or recommend specific provisions, just simply that part should be relocated so that it is covered as eligibility, not in a definition. Okay, now let me get to specifically now to Bob, his comment. Do we want to make a committee statement about eligibility? Bob, I think, is clearly, appears to be fairly clear that he is opposed to this kind of eligibility to be a board member, whether appointed or a candidate through election or either one. And frankly, I've made public comments at the special meeting to the same effect. So the question now is, as a committee, do we want to address that aspect? Is this eligibility officer, living member of a limited liability, or a living partner eligible for board membership by whatever path? Do we want to address that as a committee comment?
Go ahead, Laura. I didn't mean to. Go
I was
ahead.
just say, can we come back to that one? Because I need a little bit of time to process some of what I wanted. So Steve, go ahead.
Yeah, actually, I think I'm somewhat in agreement with your suggestion, Laura, because there are, again, going back to what we developed as a committee and what these various resolutions have come out as, I think I'm correct that there are certain provisions that we included that were not picked up by the board under 502A. And so I actually would have I was looking at when we get to 502A to sort of identifying those different areas and talking about that. Just looking at this quickly, I think the paragraph that we would be deleting under our recommendation actually might fit better than what we originally wrote, but I'm not positive about that. I'm just thinking about it. But if Jim, if your question is, do we believe that whatever language is ultimately picked up as to eligibility or service on the board, eligibility to run or service on the board should be in a different provision than in 1.11, then the answer is yes. I agree with that. And I think we will have to address the issue of business entities or corporate entities in that area when we get to it. But Unless it's the next one coming up, I don't think we're there yet.
Yeah, so what I would suggest then is, because I feel like we still need discussion time on that particular part of it, of what if we as a board want to make a recommendation or a statement concerning that. But if we just finish going through what is on the website now and like doing our recommendation here of shortening this definition, and tentatively saying that the rest of that piece would be moved to a different part of it. We keep going through that. Could we come back to then, or whenever we hit it more appropriately in these motions, to finish having a discussion on maybe a committee statement concerning,
Eligibility.
the candidacy and eligibility part. Yeah. Because I don't want to get us too muddied in one thing and lose track that we said, oh, let's stop at after the word attributable. You know what I mean? I think since we all kind of have some thoughts on it, can we table that discussion temporarily for today, but get through this part first,
Okay. Again, going back to the definition of owner of record specifically, try to say again what I earlier commented. What we are recommending is that the owner of record definition consists solely of the first two lines, and that the remainder of the definition be relocated in the bylaws and reflected in eligibility to be a candidate and eligibility to be on the board of directors. And I really stumbled through that. We're simply separating out as a definition the first two lines and separating from that the remainder to be considered within the bylaws under eligibility to be on the board either by election or by appointment.
Yeah.
If I understand Laura correctly, what we need to do is put that in an explicit motion now and vote on it. Did I come close to saying where you're going, Laura? Before we go
to make a motion that we're recommending to shorten the definition here and removing, relocating the rest of that into another portion. If we need to vote on that like that, then yes.
Okay. Steve, between the two of us, can we get together a motion on that?
Sure.
I'm talking more than I want to here.
Sure. Yeah. I actually have no problem in just suggesting that as to this particular resolution, it should be limited only to the first two lines under section 111, owner of record. In other words, as you pointed out, which votes are attributable, period, that the board's position, the committee's position is that's where that definition should end. The remainder we'll discuss when we get to those provisions, those sections of the motions.
I would second that.
Well, okay. The part about the rest of the definition, I need to back up and go over that, how to say something about that again.
Oh, I'm just saying the rest of the definition of section 111 and any references in section 501 and section 502A as to the committee's position will be covered when we get to those resolutions that the board has prepared. In other words,
okay, what the motion would be is to simply limit the not necessarily exact words, but the motion would be limit the definition of owner to record to what the actual two lines say.
Yeah.
yes,
Ending after attributable. Right.
Right.
Correct.
And
And
say
strike
that
the-
again. And say that again. I didn't get the last part.
after what Laura said, attributable period, and then you strike the rest.
Okay.
Strike
All
it
right.
out.
That would
All
be
right.
our motion for this. Yeah.
Okay, hang on. Let me try to write something down here and restate it. The motion be, it is recommended that the section 1.11 definition of owner of record be limited to, and then simply not write out, but repeat exactly what's there. Hang on a second.
The first complete sentence,
Right.
because that's just one really long sentence, but it ends at attributable. So unless I'm missing a period, but that is the first full complete sentence. That's what we're recommending our motion be for the definition of owner of record in section
Okay, well-
1.11.
Let me make a suggestion here. I would personally be a little bit more comfortable by literally writing out what we recommend to be the definition.
Okay.
In other words, it is recommended that the owner of record definition be stated as owner of record, and then there's 2 lines.
Correct.
Yes. Correct.
Okay, hang on a second. All right, here's the motion, and we can change it to whatever I've got wrong here. Motion, it is recommended that the definition of owner of record be stated as owner of record means the persons listed on the deed recorded in the land records of Worcester County as the owner of property / parentheses grantee / party in the second part into parentheses within the subdivision to which votes are attributable. However, I stumbled over that. It just repeats the definition.
That's
Yes.
correct.
Correct.
Okay.
Okay, Jim, can I just interject something here?
Sure.
All of these motions pertaining to the bylaws change referendum are stated in the format of to have council develop the appropriate wording for a referendum to amend the bylaws to a new section 1.1 to read as follows. And then you put in what you just put. Okay, so you
Okay.
take, and I think that tells us that you want us to amend this motion that we
Okay.
already have.
All right. So we're going to include that as part of
Yes.
the motion.
Okay,
All right. So again, the motion would be to have council develop appropriate language for a referendum to amend the bylaws to a new section 1.1 of the bylaws. And then it doesn't have to go on to 501 and not 502 at this time.
okay, so your
Right.
motion would be that the board consider amending the motion to read as follows. And then the motion would be to have council develop ... to votes are attributable.
Yeah. Okay. Yes.
Okay. Thank you.
All right.
I can work with that.
Anybody have a second to that?
I'll second that motion.
Okay, Bob seconds. Steve, I guess that's your motion, so. Bob, Steve and Bob. All right, we have 4 members of the committee present. With anybody in favor, please say aye.
Aye.
Aye. Steve's missing.
Where'd Steve go?
I don't know.
Well,
He'll be right back.
we'll hold the vote open for a couple minutes.
Okay. Yeah, just deviating from this, remember, we spent almost an hour on this one issue and we have another major one coming up. So from time management, we need to look at it.
Yeah, you're right.
Okay, here's Steve back. Maybe he can vote on his motion.
Steve.
I'm sorry.
Okay. All right, there's no nays or abstentions, so the motion is adopted. I will have to get this in writing to you promptly, Colette.
Okay, thank you.
All right, we have to move on to 5.01 here, and we can set this aside and wait until later on, but somewhere later on near the end here, and it's on the same, as long as it's in the notice materials that's going out, there's I'll call it proposal to amend the charter. And that proposal also has in it a proposed amendment to 5.01. Is that still in the package that it's toward the end, if it is in this package? Is it still on the website, if I can put it that way?
I believe it is. I'll look
Okay,
at
so-
the end of the website here. So
It's-
there's
it's
one
in-
vacancies, there's one, yes, purpose of revising our charter. It's second to the last
Yeah,
of the motions on the website.
okay, well, we've got the same section twice. So they're virtually the same with the exception of the sequence of the sentences. And in the one that's the very last one, there are a couple of different words added in there. I hadn't really intended to go back there. Josh, can you go? It's what, the second from the last one. Josh, you still
1
with
second.
us? Okay, so don't mean to be bothering you.
That's a motion to hold a special meeting for the purpose of revising the charter,
Yeah,
which we have not done yet.
Is that correct?
Is that what you're referring to, Jim?
Yes. The difference between the one that's on the owner of record and the one that we have here is that there's a different sequence of the sentences. The content is the same. The other thing that was a couple of different words. No, it's got of real property in it. That's all right. No, I'm sorry. I'm in danger of making a mess of things. I don't believe the word real property in that second line is in the one that's on the same as the definition. In the section, where is it?
Well, it depends on what's in the,
I'm having trouble following what I'm looking at here, guys. Shall be managed by of whom shall be an owner of record of property.
Yeah, so you're correct, Jim. Real property does not occur both places.
Yeah, it doesn't occur in the one with the definition, and then there's another location. The 1, 2, 3, 4th line down, and the one we're looking at has the bylaws. I believe the other one says something like these bylaws. Maybe yeah, the last line of the definition motion part says 502A of these bylaws. Here it says 502A of the bylaws.
And which would be correct? These.
I haven't looked at what I haven't looked at what's actually in the bylaws now.
Well, I think elsewhere in these motions, when we have referenced the bylaws, we have referred to the Ocean Pines Association bylaws for any language change. And so I think these or Ocean Pines Association bylaws would do the job.
Okay, I don't see any reason not to. That would then leave out owner of record of real property, leave missing real property in the red part on the definition page doesn't have the owner of record of real property.
But it sounds like you want it to be consistent.
I think we was technically correct. It would be, I think we should be referring to real property.
Yes.
So
And so you want to change that in your motion to definition of owner of record then?
Yeah.
To state that the land records of Worcester County as the owner of real property within the subdivision. Is that what you're saying?
yeah,
Okay.
let's I want to make sure I don't completely confuse all of my papers here. I think we need to have another motion we're looking again at the page that has the owner of record definition on it, and down at the bottom where it has section 5.01. We're talking about on the second line where it reads, an owner of record of property should read an owner of record of real property.
So
Yeah.
you can amend your motion to
Well,
make
we
that
can add-
wording change.
We can add to it a second part to the motion. I'll make that motion that on this 5.01 not definition, 5.01 proposed amendment, that the word real be inserted between of and property so that it reads owner of record of real property. Let me write that out. Hang on a second. This is getting too long for something that's not that hard to do. All right. The motion would be it's recommended that section 5.01 be amended in the second line to read owner of record of real property. And just leave it at that. It be recommended that it read owner of record of real with the italics or whatever, owner of record of real property. It's recommended that section 5.01 be amended to read owner of record of real property in the subdivision. I'm going to just call that the motion as any second.
Second.
Okay, that was me. That one's Steve. Any further discussion? Okay, all in favor, aye.
Aye.
Okay, no, any nays? No abstentions? Okay. All right, that,
Can I just point out one other thing, by the way, the discussion you just had with
Yeah.
as to whether it says the bylaws or these bylaws. have the same issue down on this page. It looks like the underlying sentence that follows the first paragraph of 7th of the charter shall be amended to add the following after the existing first sentence. The qualifications for candidacy, comma, election and service on the board shall be as provided in the bylaws. So if you're going to change the bylaws to these bylaws or some other reference to the bylaws, you should be consistent in both paragraphs on this page.
Yes.
Well, yeah, again, I don't want us to get hung up here, but actually, if the section 501 on the motion page that includes the charter references, if that's going to be disregarded, for lack of a better term, or set aside, whatever, I'm not sure what the purpose of the charter information has. It's not, the charter has nothing to do with the bylaws. I mean, I understand that the charter amendments are going to have to be made to make valid some of the bylaws changes, but the charter amendments are entirely separate from the public hearing. So I guess what I'm questioning is this whole with what has been done with regard, or what we think should be done with regard to section 501 on this ladder motion page. This entire page really shouldn't be a part of the public hearing unless the board wants to say we're going to have to change the charter too. But it's not the charter part of this is not a part of the public hearing.
Right, you're correct about that. This can be dealt with later. That's a separate issue.
And Steve's comment is perfectly correct. It just does, it's something the board can take care of on its own without anything further that needs to be considered.
Right, and I'm making note of those, need to make those changes.
Okay.
When the board gets to that.
I am getting concerned that I'm getting myself way out of order here. Okay, I guess not. All right, we've I think we've gone through this motion that includes the owner of record definition and the section 5.01. Is anything further we need to talk about on that? All right, Josh, what do we got up next?
You tell me. We went to the end, so I got to go back now.
So you're at 502A, candidates for election, annual charge dates.
Okay,
That just went from what?
again, I would have to go back. I'm pretty sure I've done this in the last 24 hours. Is there not a motion for 502A III, which would read, no member shall be candidate for election as a director of the association if he or she is an incumbent director completing a second consecutive term, has a familial relationship through marriage, parentage, or sibling, or any other member currently serving on the board. I have, again, unless I've missed something completely, I think that it is or has been at least on the website as a motion. This is not a case of me bringing it into question. I have no questions. I personally have no questions on it. I just want to make sure that we're accounting for all of the live amendment proposals, if I can put it that way. I'm
not sure where we are at this point.
All right. Josh, can you put up what you had next?
This is the next one that I had in the packet.
I put it up.
Oh, I see. It dropped off the, okay. Can you see the attachment now?
Yes, I can. See, my concern is that there is in fact another one that the motion says, section 5.02, candidates for election, A, eligibility, triple I. And this is the one that covers whether you're an incumbent director for the second term or completing a second term, you're not eligible, nor are you eligible if you have a familial relationship through marriage, et cetera, et cetera. I don't think that's covered anywhere else in what we have, unless I'm off. Again, I'm not
Yeah, Jim, we
questioning.
did have one, and I'm gonna go to my other desktop computer and see if I have that motion. That may have been inadvertently left off. So if you
Yeah,
want
I'm
to
not-
proceed, I will go ahead and look for that.
Okay, I'll set it aside. The next one up, Josh, is the one that has the, in addition to the requirements contained, this is the you got to pay your annual charge motion. Yeah, that's the one there. Again, this is part of our proposal. It's just expressed a little bit differently. But we also wanted to particularly highlight that you had to have paid that part of 301C pertaining to your annual charge obligation and assessed interest. We did have that as part of our proposals, although this again is a Frank Daly proposal. I don't want to, we are in fact starting to run long, and I don't want to rush us along. But this is consistent with what our proposals have been. Does anybody have any comments on that?
This was the language to deal with the fact that there are different dates regarding the due date of assessments and payment of interest.
Yeah, that's right.
So that in theory, my recollection is most members have to be paid up by September, whereas if you're a candidate, you had to do it by the time you filed your application on or about May 15th.
Yeah.
Yeah,
That's correct. This clarifies that you don't have that 35-day grace period if you're going to be a candidate. Okay. All right, Josh, moving right along. Okay, this is another Frank Daly motion. This deals with the candidates and felony convictions. The original motion dealt with a 10-year interval, and in the special meeting and after discussion, it was modified to a 5-year interval, except that it was 5 years after completing the various commitments like probation, restitution, etc., that may have gone along with the original conviction. So it was shortened to 5 years, but it includes provisions for any interval beyond 5 years that it takes to complete probation or other requirements having to do with the sentencing for the conviction. Obviously, it's not identical to the same, but it's intended to achieve the same purpose. And we had discussion, I believe, of a 10-year interval. Does anybody have any comments on this?
Yeah, just briefly, I'd make 2 comments, and I'm not necessarily suggesting we need to change anything here. There was, when our committee discussed this, someone, and Jim, it may have been you, but I'm not sure, made the point that there's a difference. There may potentially be a difference of being convicted for a felony in one state, which might be considered a misdemeanor in another state. And that is true, but I don't know that that's crucial. The other point that I would make is we actually move this whole question of felony conviction. The language is different, but we move the felony conviction issue over to the candidate application form because we had made a distinction between that which directly affected the association, that is assessment payments, complete, going beyond your second consecutive term, familial relationship, employee of the association, that sort of thing, and other issues that we think the voters should be aware of. And so, and I know because some of this is not going to get picked up in time for the next election, it may go back onto the application form, but I'm just making this observation that this is a little bit different than what the committee originally had worked on.
Yeah, I think that's understood. Yeah, this puts it in the bylaws.
Yeah.
As opposed to what amounts to an information item on the application.
Correct.
That's entirely correct. And I don't think there's anything we need to comment on that. That it's the board wants it on the bylaws, so we'll see what happens.
We'll defer to their.
Go ahead, Steve. I'm sorry.
No, I just said we'll defer to their wisdom.
Okay.
Yeah.
Such as it is.
Okay. Remember, we're on video here, guys.
Okay.
What's next, Josh? Okay, this is again a candidate for election and the eligibility consideration. This is the one that deals with the candidate being a party to a lawsuit involving the association. We had talked about that. But frankly, I don't remember what all we talked about. Again, this is a Frank Daly motion. The candidate can't be a plaintiff in an active lawsuit in whatever court against the association or the association's directors named as director, and can't be a defendant in an active lawsuit in which the association is a plaintiff. That deals with adverse positions in lawsuits and eligibility.
Right.
I personally have no comment on it.
Again, this is something we put in the election, the candidate form, not in bylaws, but again, if the board wants to put it in the bylaws, it goes in the bylaws.
Yeah, that's fine. Anybody else? Okay, moving right along. Next one should be search committee. Well, I'm straining to see what I got on my computer screen here. All right, this is a modification to 2502 to 502B, and then followed the next one is 502C, both of which pertain to search committee and search and applications. We never fully got to a search committee, separate search committee proposal, although it's included in the Article 5 proposals of our bylaws proposals document. I don't have a whole lot to say. There is a comment I need to make, but I want to step back here and make sure others a comment. There is one thing I think does need to be modified, but again, others, what other comments do we have, if any?
Well, we discussed the search committee at least once before that I can recall. And I was actually impressed by the fact that the search committee felt that there was no reason for them to exist. Colette pointed out that the board was interested in sort of expanding their reach and their what they do in terms of keeping everybody informed as to what's going on and that sort of thing. I don't have a problem with that. I have to say, if the if the committee's inability to acquire at least 2 more candidates, the number of vacancies doesn't affect the validity of the election, and that's why we're constituting the search committee, it sort of raises the question, why is there a search committee at all? Regardless of whether you give them extra duties or not. Again, I can only go by what I read online in a couple of different places. It seems to me right now the membership of the association, there shouldn't be a problem in finding additional candidates, but I don't know. I mean, again, I'm the new guy, so I'll just leave it at that.
Okay, I wish more time had been, I wish we had had an opportunity to make a I'll call formal search committee proposal to the board, but that didn't happen. And this is what we're dealing with, both this motion and the following one. But at any rate, the last line says, the committee shall submit a list of candidates to the secretary not later than May 15th. Well, that actually conflicts with what comes on the next. I don't have any, we can combine that comment with now a consideration of the next motion C. Just keep in mind that the last sentence on the one that we've had in front of us says the committee shall submit a list of candidates to the secretary not later than May 15th. Okay, if you go to the next motion, which is candidate applications 502C, in the middle of there it says the form shall be submitted to the secretary or assistant secretary not later than May 10th. That you can't have that in the last sentence of the prior motion. One or the other has to go, and my suggestion is that the one on the prior motion that goes for a list of candidates goes from the committee to the secretary is the one that should be deleted.
So my question would be, in the previous one with that sentence that says the committee shall submit the list of candidates, right, or something to that effect.
Yeah.
But right before that, it also says that the lack of a committee does not affect things. So if there happens to be a particular year where we don't really have a search committee, that's working, who's sending the list then? That to me doesn't match anything. So I think I would rather see it match this that says the secretary or assistant secretary. To be, I don't know, the previous one was just a little bit confusing as far as you're going to say it doesn't matter if we don't have a search committee, but if we do, then they're the ones who send it. But it doesn't clarify what happens if there is no search committee, who then is responsible for all of that.
Yeah, I think, Laura, what has happened in practice is that the applications have gone to the assistant secretary. So I think you raise a good point that the committee doesn't really need to handle the applications. The committee's job is to search for people who would like to submit applications, and those can be submitted to the secretary or assistant secretary.
Right, from the candidate themselves would be submitting it to the secretary.
Yeah, which is what this motion you're looking at says.
Right. Correct.
Right. Yeah.
The problem you have is the 2 dates are inconsistent.
Right.
Yeah.
Yeah. So I think the board wanted it to be May 10th because that gives the secretary a little bit more time to, verify that the candidate meets the qualifications.
Right. So the search committee would have to complete their work
by then too.
May 10th, or actually probably by May 9th, technically, but by May 10th.
Right.
But if you cut them out of handling the applications, then it's not a problem. It's incumbent upon the applicant to get their form to the secretary.
Yeah, in my opinion, there's never been any reason for the search committee to handle handle
Right.
applications, but that's the way the bylaws have read now for 12 years,
Yeah.
14 years.
Yeah, and having been the secretary, what really happens is they go to the assistant secretary, she holds on to them. She hands them over to the search committee chair who signs off on them, who hands them back to her, and then she hands them to the secretary.
Yeah,
To-
and that's a completely
Yeah.
unnecessary
Right.
loop in there.
Right.
And we take that one sentence out and go with what's in the second, subsection C. I think we're avoiding that or eliminating that loop.
Right.
Okay, we effectively are covering two different sections or two different motions here. And we've,
So should we go back, do the first one right before this to say to amend to strike that sentence talking about,
Yeah,
the section there?
you
And do
want
that
to,
separately and then do this one? Or is that,
do we actually need to make a motion on that, the elimination of the search committee list?
No, I can take that to the board.
Okay. And, okay, then on the second one, where we've got the secretary or assistant secretary part, there's nothing on that we need to comment on. Is that a correct statement on my part? We're going to leave that alone, so to speak.
So what all you're doing really is striking the May 15th date in 502B. That's all you're doing.
Yeah, the 502, the date as well as the participation of the search committee. It says is the committee shall submit by.
Right. Yes. I understand. Right. I agree with that. Yeah. You just strike
Okay.
that last sentence. That's fine.
That takes care of both motions. Okay,
that'd be fine.
all right, what's next?
Let me know if I'm one behind or not.
I've got what you've got. Let me put it that way.
Hey,
All right, this is a Frank Daly motion. And it describes the process to be followed when there is information coming forth. And this is my description. Where I go wrong, somebody correct me. It describes the process to be followed when there is a question regarding the eligibility of a candidate and what is to be done at various points in the election process. If there is an eligibility question, and in particular, what happens if the secretary determines that there is in fact an ineligibility situation. Let me make one comment and step aside and let everybody else comment to the extent that you may wish to. It says if at any time after May 15 and prior to the certification of the election of directors, the proper word should be validation rather than certification. Validation is the term that's used in the bylaws. Again, I do have a question later on, but I want to make sure that everybody has their opportunity to comment to whatever they want to on this particular, this proposed amendment.
Well, I have a lot of problems with this provision, and I know we're running out of time here, but this is markedly different than what we drafted as a committee in a couple of different respects. And part of this goes back to reading the opinion of the judge in the FAR litigation. And I hesitate to, I'm not interested in relitigating all of that, but I just, one needs to keep in mind that the judge cast, what should I say, aspersions on the notion that somehow the secretary was informed of a problem of Mr. Farr's candidacy, and the language in red there, based on further information that comes to light, seems to raise the very point that the judge was speaking about. The other issue tied to this in my mind, by the way, well, let me is that all of this lies with the secretary. The secretary makes the determination that there's an eligibility requirement. The secretary is the one who's solely responsible for that action. And it was my view, and I think I stated this when the committee considered this, that there's a different functions that a secretary performs. They tend to be more administrative or ministerial, if you want to use that term. The notion of taking eligibility for a candidate away strikes me as being far more significant than that. And the fact that the only requirement is that the secretary has to act in consultation with legal counsel and association staff is to say the least, sort of a loosey-goosey definition. The other point that I'll make to you is that our amendment crafted a procedure for the board to follow, which is the secretary prepares a report, forwards it to the board takes the matter under consideration and provides an opportunity for the affected candidate to respond to the secretary's report prior to the board voting on the motion to judge eligibility. Now, I will say to you that, and again, I'm doing this by recollection, but Frank Daly pointed out at the special board meeting that the issue that he saw, and I don't disagree with him necessarily, but the issue that he saw was potentially because other board members would be up for election at the same time, you might end up, instead of having a board of 7 voting, you might only have a board of 4 voting. And that's true. You run that risk. And if the motion were to be 2-2, the motion fails. There's no question about it. But the question is whether or not you want to vest A, the authority, and B, the blame for this on the secretary, or whether or not you feel it's more important that it be taken, that the board take this action as a whole. So I would commend to the board, to the committee, that what the committee put together in this area is preferable to what the board included in this motion.
Colette, I'll ask a question here at this point.
Okay.
With regard to what Steve just said, is this in fact something, well, apparently this has already gone through the attorney, is that correct?
Yes,
Okay,
that
so
is
this,
correct. And you were present at the special meeting where it was discussed.
yeah,
So you've heard, there was quite a bit of discussion about this.
I personally prefer to go with the secretary being responsible. Now, the in consultation with legal counsel and association staff, I'm not sure association staff belongs in there, but at any rate, this is what's come out of due deliberation and the association attorney, and I'm not, I don't particularly support trying to turn it a different direction at this time. We're kind of out of, it's kind of too late. If we'd have had an opportunity to look at this kind of thing a month and a half ago, 2 months ago, before it got to a special meeting of the board of directors to actually adopt, maybe so. Maybe that would be a different, that'd be a different situation, but it's not. We're really after the fact here, and the train's really going down the road, or the tracks. Claude, if I do have a question, and let me add mine to what we're talking about here. it starts out, if at any time after May 15th and prior to the validation, I'm going to say, of election of directors, whether you call it certification or validation is the same thing. For this discussion, it is. What this continues on to say, well, leading up to the ballots having been sent, it's clear cut. You know, the ineligibility determination made before the ballots are printed and sent out. The ballots don't go out with the name on, the ineligible candidate's name on it. Now, the way this reads is that once we get the ballots out and the voting started, what happens next is essentially, and I'm going to disregard all of this bad faith, wrong actions by the board and whatever else, and just deal with simple facts, what I consider to be simple facts. Once the ballots are out, the same thing happens as what happened in this last election. A determination of ineligibility was made, it was made public, and in effect, what happened is the voting continued on there with whatever results came in after the public disqualification. There is no part in here in which the board or the association, let me phrase it that way. There's no part in here in which the association withholds any public release of an ineligible consideration or determination. Is that's the way I read this? Is that correct?
That's correct.
Okay. In effect, again, I'm going to start with the ballots have gone out. In effect, not in effect, this process actually says we're going to do the same thing we did last time and deal with whatever fallout there is.
Yes.
Okay, I just wanted to, I want to make sure that that was the correct understanding. Let me put it that way. Anyhow, for further comments.
The only comment I have is the application form itself, as Colette said very early on in one of our meetings, it should be the responsibility of the candidate to fill out that form properly. If there's any untruths or facts not reported properly in the form that invalidates them, so be it. But, and I would agree that since any case can be litigated, it's best for the board not to make an announcement after the ballots are sent out that that person's invalid, because it could go to court and they rule in his favor. So I think the whole burden goes back. And again, this thing only happened one time in what, 50 years or 55 years. So I don't think the risk is very high. So I don't see any problem with the way it's written.
Well, I don't disagree as to where the burden lies in terms of filling out the application correctly, and if there's any falsehoods, it's the candidate's fault. I don't disagree with any of that.
Right.
I will point out, particularly in light of Jim's comment, which is essentially once the ballots are out, they're going to follow the same procedure that the board wanted to follow during the FAR litigation. That to a certain degree, it's fair to say that some of the most significant parts of the judge's opinion in reaching the decision that he reached is unchanged. He cast aspersions clearly. He cast aspersions on the information and the way the information eventually got to the secretary. He pointed out that there was no Mr. Farr was not accorded a proper opportunity to respond. Again, this is all foisted on the secretary, which the judge's opinion clearly points out. Well, she was a lawyer, she should have known, as opposed to the board taking an action of this significance. So, I mean, I understand what Jim's saying, you know, the train probably has left the station, but we should at least acknowledge the fact that in large chunks of the judge's opinion, this resolution changes absolutely nothing.
We would also need to take in consideration that not every secretary has the experience of being an actual lawyer. So we can't, if we're going to follow that, the judge's line of thinking that the secretary should have known or whatever because they're a lawyer too, well, all of our secretaries more than likely have not been lawyers. So we want to make sure our verbiage is understandable by anyone who doesn't have that legal background too, you know, as far as their duties and responsibilities.
Laura, I agree with that. That's not, the point is not that the secretary should or should not be an attorney. That's not my point. My point is simply that the judge pointed out
Right.
that, you know, she's a lawyer. She should have known what to do. And that was brought to light by plaintiff's attorney. So I'm not saying that's not my point. My point is simply that if you're going, that deciding on the eligibility of a candidate is far different to me than going through the process of certifying somebody or something like that. This goes to the basic electoral process that the association follows. And to me, and at least in terms of what we drafted as a committee, that is something that should lie with the board, not just with the secretary. That's the point I'm trying to make.
Okay. It's been a while since I last read the opinion. I think a criticism was addressed toward to the governing documents, for lack of a better description. Bylaws, for example, do not have a process for dealing with the situation that was presented in the FAR disqualification issue. And this is the process that's being proposed. The way the process, the details of the process may be debatable, except it's kind of, again, it's kind of too late to be debating in that in any kind of a detailed context. But this is the process that's being proposed and would be the process that answers what do we do when confronted with a disqualification issue, and this does that. I don't have anything more than I can add. I'm kind of I don't know that we have really a consensus to make any particular comment on that, on this proposal. Any comment on my comment?
So Jim, you had said earlier that there was a place where the word validation needs to be inserted, and I didn't find that spot. Could you tell me again where that is?
It's at the very first line where it reads, if at any time after May 15 and prior to validation, not certification.
Okay,
That's we validate the election of directors.
right. All righty, got it. So I'll make that change.
Okay, guys, let's keep moving here. What's next, Josh? I think we're going to pretty well run out of comments from the items to comment on. This is a Frank Daly motion, and it addresses the situation in which, after the fact, meaning after a director has been elected, or not necessarily elected, has become a member of the board, whichever election or appointment path is discovered one way or another, that there was in fact a past felony conviction. And this makes it, this puts it in the cause for removal from the Board of Directors category. And it specifies that the felony conviction obligations, fully completed all terms of the sentencing, has not has been within 5 years, then that makes it a cause for removal from the Board of Directors. Again, this is a new provision.
Okay.
I don't have any comments. Let's put it that way.
No, this tracks the 502A language that we did previously.
Yeah, it's a
Yes.
same kind of thing, except that this is a member of the Board of Directors.
Goes to 512, not 502. Yeah.
Right, yeah,
So
okay.
just for my clarity and my memory then, is this is talking about someone who has already been either appointed or elected a director, and then it comes to light that they have been or are being charged with a felony
Convicted.
that and then has not fully completed all terms of their sentencing within the 5 years stuff. How are we finding out at that point if they're already elected or appointed that they had a felony?
I'd have to say, I don't mean
Is
to
that-
be
is
trite
that a-
by this, by whatever
Yeah,
means
phone call.
becomes available.
Okay.
You know, Somehow-
There's no obligation that we search for that information, but if the information comes to light through
After
any
they're already
means,
in.
then
Mhm.
that could be a cause for removal. It's not a requirement that
Gotcha.
that they be removed, but it could be a cause for removal, is all this says.
All right. That's fine.
Okay, anybody else? All right, let's move on to the next one. This is, again, a Frank Daly motion, but its intent is identical to one, a similar one that we had. It's just relocated, not relocated, it's located within the officers and portion of the bylaws. I forgot exactly where we had suggested that this provision of resigning from the secretary's position. I don't remember where we exactly had proposed that it be placed in the bylaws, but this one places it in the officers portion or officers article of the bylaws. To the secretary has to resign upon filing a candidate application. So it's the same as ours, except different location. Any comments on that?
No comment.
Okay, let's keep going here. Next up, Josh. This one's going to be, should be, hopefully, the provision regarding the informal action. This again is our proposal to replace the current bylaws provision regarding informal action. That's a so-called email action, maybe another reference, slang reference to what's going on here in this bylaws proposal and bylaws provision as exists now. It just simply refers to the Maryland Code provision, so that in case there's any changes to the Maryland Code, we don't have to rewrite the bylaws. And secondly, there is an intention to make sure that it is a unanimous action by the board, not a approval of a board motion, as it would be under the bylaws majority vote of a quorum, for example. It has to be unanimous. This is intended to make sure that that's clear. Otherwise, there's no real change in any intention of amending this provision. And again, it's going forward as is our proposal originally. Any comments on that?
No.
Okay, I'm going to keep us moving here. Next up, Josh, is this is the one that deals with the amenities membership for persons on the board of directors, whereas the current provision in the bylaws lists the various amenities. This simply lists a family membership provision rather than listing each of the amenities. In our proposal, and I believe this came up after Colette, you were there, or after you had to leave the meeting. We had proposed to insert in there that there cannot be paid a salary to the board of directors. That is not in here, and the reason not in our proposal. It got to you or the board, and that was my fault. I did not get that communicated. However, during the meeting, I was trying to find something in the board of director, I'm sorry, the charter, which I felt applied, and I did not during the meeting. But there is a provision in the charter that says that no part of the income of the association shall inure to the benefit of the directors, officers, or members of the association. And that provision would preclude the directors or officers from receiving a salary simply because they occupied that position and that position only. So it would not be necessary to put in this resolution, or not resolution, in this section amendment, would not be necessary to put in there that the directors cannot receive a salary, that they are prohibited from receiving a salary by provision in the charter anyway. There's no reason or no need to repeat that. There's no reason, you can't put in a salary provision where it's precluded by the charter to begin with. Hopefully I haven't confused everybody, but I'm just trying to explain that there was something we put in our proposal that didn't make it in here.
Mhm.
And there's, by accident, there's good reason it didn't make it in there. It couldn't get a salary anyway.
Okay. So no changes to this one, huh?
No change. No, not at all. We're running out of time, and I don't want to keep going here. Our next one, Josh, you got it. This one should be yep. I don't have any comments. This is a companion to the year ago referendum that passed to reduce the 20% of current income on a capital expenditure authorization. This effectively is a companion to it by board proposal to limit the board's authority to be able to sell, mortgage, encumber, or whatever association, real or personal property to a no more than 10% on a 2/3 vote of the board of directors.
Why is that a proposed motion when it's already been approved by the owners?
Well, this deals with the sale of sale, mortgage, or encumbrance or donation of common property of the association, or association, real or personal property. It's not, doesn't have anything to do with the capital expenditure proposal.
Okay.
This read 20% previously, or I'm not previously. It reads 20% now, and it doesn't include the 2/3 affirmative vote. So it reduces the authority of the board of directors to sell, mortgage, encumber, and so on. And you know, I don't mean to confuse things by saying it's effectively a companion piece to that earlier referendum, but it's entirely separate.
Okay.
But it's a limiter on the board of directors is what it is.
Okay.
Okay, I'm going to take it. We don't have any comments on that. Next up is one of ours, and this again is this reference to source documentation for what is done in this case. It's the execution of checks and contracts and so on. Again, this makes reference in general terms to the financial policy and procedures manuals. Again, this is our proposal as part of the how to perhaps more properly refer to other than source within the bylaws type information for how to do something. And again, it's our proposal as is. Any comments? Okay, moving right along. The next one is the same thing. This has to deals with designation of depositories of association funds and so forth. And again, the reference is made to the financial policy and procedures manuals in general terms, not to a specific financial policy manual or financial procedures manual, which do in fact exist today. They're not up to date, but they do in fact exist today. Again, our proposal as is. I don't have any comments. Let's go on. We've already talked about the next one, I hope, which is next on Joss's list here.
And this one needs to be removed from this packet because it doesn't relate to the bylaws amendments.
Yeah, I take it going with the other 501, in deleting this 501, there's no relationship to the public hearing.
Okay.
All right, last, I hope, Josh. Yeah, okay.
That has to do with vacancies on the board.
Yeah, appointed directors must be, okay. Would it be better to read appointed director shall be an owner of record? That's the only comment I have.
Okay.
Also, real quick, I see section 502A.
Yeah. I think we're missing a decimal.
Where are we here? I don't.
You're right. Okay.
Bolded.
Typo.
Yeah, in the bolded part, it's at the
Yeah.
end.
I see it too.
It might feel like number 502, but
Yes, indeed. And so, Jim, you are correct about 502A3. And I emailed that to Josh and to everybody on the committee. That was left out of this packet. I will go back through the packet, make sure nothing else was left out or put in that didn't belong. Josh, that should be in your inbox. Could you bring that one up?
Yep, just a minute.
Okay, we don't have anything further on the last one we were looking at, the
504A.
502A and owner of record. Okay. Well, the one that's on the screen now, we're finished with that one.
I do have a question. And I may have missed it, probably did miss it, frankly. My recollection is committee in addressing 502A eligibility included the language relating, or the modified language, I can't remember which now, dealing with the assessments and the fact that the incumbent director not completing a second term. Okay, so it does have familial relationship. That was what I was trying to get to. What I don't see is the other provision that we included about being an employee of the association.
Yeah, and we did approve a motion having to do with that. My guess is that got left off.
I saw it as a charter amendment.
Right, but let me go back and make sure. Let me go back to my desktop and see if
Somewhere
it's.
that should be in there somewhere.
Well, I may have missed it. But what I was saying, there's a charter amendment dealing with employment an employee of the association not serving on the board. It does not get to eligibility. It's only being on the board. And we had included it in 502A, as I recall.
I don't specifically recall that, but that's all right. There's a lot I don't recall.
Article.
I- Oh, boy. I knew my papers would go south here sooner or later.
You're lucky you held up this long.
My thoughts exactly.
Yeah.
Come on, why is
Here
it not
it
here?
is. Okay. So we had motions having to do with 501A. 2 had to do with the annual assessment. 2 had to do with, I don't know what that was. Let me look. That was annual assessment. And then there was incumbent and familial relationships, which was 3. 4 was employee, that you could not be an employee of the association. And that was for a candidate. So you're saying that we didn't have it for directors.
Well, it does say in 501, no member of the board of directors may at the same time be an employee of the association. We had also included language in the eligibility issue, which is 502A.
Right.
There's
And-
in this packet, I saw it before, there was a charter amendment also dealing with employment, which I tracked sort of 501. But it was, you could not be a director if you were an employee, which is what 501 says. It didn't get to the eligibility question. Now, maybe that's a distinction without a difference. So
Let me pull out the packet of motions that we acted on, just a sec.
Well, Colette, could you say that again? I didn't fully hear it.
She stepped away to her other desk for a minute.
Oh,
She's
okay.
walking.
Changing office.
Well, you know, while she's gone, we can actually get into that question. We need to cover resolution M09. Yes, guys, we're running late, but we got to do that because that's something that Colette for sure has to get ironed out between now and the next board meeting, or next regular meeting, at least it's planned. A concern I have about addressing employee and being a member of the board of directors. It's not truly a candidacy issue. It's whether or not an employee can go on the board of directors if elected. Now, yeah, it would be not a very good idea, in my opinion, for an employee to be accepted as a candidate and then be on the ballot and still an employee, and we run up against the time when the votes are counted and that person turns out to be a winner and is still an employee. Now you're in the legal gray area. What happens then? Can you allow the employee to resign before the election is validated? Reading the votes after they've been counted is one thing. Validation is the official going on to the board of directors. When the validation is conducted, you're on the board of directors, whether it's at the annual meeting, if there is a quorum, or a special meeting of the board. At what point in time do you get into a gray area of you disregard those votes and go to the next winning candidate, or you declare a vacancy on the board of directors. You get into that kind of an issue. But to me, technically speaking, you can be an applicant and be an employee. But
Right.
the further that goes, the more we get into a gray area. Now, how to address that? It's not being addressed in the bylaws right now, or proposals for the bylaws, let's put it that way.
My personal thought would be, if I was employed, but I also wanted to be a director, then I have to make a personal choice. Do I want to just totally resign at the beginning of the process? And then let's say I don't get elected, but now I don't have my job either, and I would have kept my job if I didn't get any of the winning votes, to be on the board. So would it be appropriate to let them be able to keep their job until that validation prior to that validation, like you suggested? And once the votes are tallied, if they realize they are going to make it to be to fill one of those vacancies, give them an opportunity at that point right then to resign from their job. Then you can finish validating and move on. Or do you want to make it a risk that they just say you have to resign prior to that, and then hope that if you don't become a director, that maybe that vacancy in your employment area would still be there and they'll let you have it back? You know what I mean?
Yeah, I'm trying to think through it.
Well, you're always going to have that devil's bargain between
Right.
I want to be on the board and I want to have my job. Which do I do? So during the campaign, I have both. The difference is that 501 already says no member of the board of directors may at the same time be an employee of the association. We're already saying you can't run if you have a felony conviction, if you're a party to a lawsuit, if you haven't paid your assessments on the stated time. I don't know. The alternative would be, okay, suppose the employee wins and then decides, well, no, I think I want to keep my job, so I'm not going to leave the board of directors. So now you have another vacancy right after the certification of the election or the validation of the election. It seems
Right.
sort of cart and horse problem.
Yeah.
I
So,
think it would almost be better to have to say that, to have the candidate take the responsibility to make that decision prior to submitting their application, whether or not they want to be looked at as an employee applying, or, and if they want to go ahead and commit to doing the process to run for election and all of that, then they have to be able to not be an employee at that time.
right, and that is precisely what the committee had drafted. In the eligibility section, I don't remember the exact date, but I think it was something along the lines of that the person who's an employee must in fact have resigned from employment by the date, was it May 15th or May 10th? I can't remember which, that the application is submitted for certification. So, I mean, you get right up to that date, but then you've made your decision.
Yeah, well, that would be the most clear-cut way to approach that, the employment situation, in my opinion.
Right. And I don't think that was picked up in this package of resolutions. That's my.
Yeah, it isn't. That's correct. It
Yeah.
isn't. You can't, an application from an currently employed member of the association, currently employed by the association member, it is not accepted. And then the not being able to serve on the board is already there.
Right.
Right.
It's in 501, but it's not in the eligibility of 502A.
Yeah, Colette, I don't know that.
Let me look at,
Is there a point? Is there a point for us to making a comment like that at this time? Probably not.
yeah, that would be another we had a motion. I thought that had to do with being an employee, but I guess,
I don't recall one. I don't recall.
yes, you may be right.
Well,
Yeah.
there is a charter amendment dealing with that question, but it does, I think I'm correct, it does not address eligibility. In the package that we worked from today, when we flipped over to the charter amendments, I thought I saw something about employment, a ban on employment, but I don't think it got to eligibility.
My papers are much too disorganized to easily find them.
Yeah,
right
that
now.
is where it is, Steve. You're right.
Okay,
So
What-
that I think we would take care of in the charter, which supersedes the bylaws, so we wouldn't need a bylaw.
so, and Colette, if I'm understanding you correctly, what you're suggesting is to have a charter amendment addressing employment of the association as an eligibility criteria. Is that correct?
That's sure what it looks like Frank had in mind. He's kind of mixed the 501 with the charter. I'm gonna have to look into that because. So you're saying it's not in the charter right now, it would have to be added.
No. I thought I saw, and I can be wrong, but I thought I saw in the package of board resolutions that we've gone through today, there was
Yes,
a charter amendment dealing with employment.
yeah, that's actually
Quickly,
a
it did not
change.
to eligibility of a candidate. It applied to service on the board. I may be wrong.
Yes, you're correct, Steve. It is here
So
in
my,
section 501 of the charter. It says the terms of the director shall be for 3 years and until their respective successors are duly elected. No member of the board of the directors may at the same time be an employee of the association. So
Right.
it's in the charter
which
now.
tracks. I'm sorry, Jim, go ahead. I didn't mean to interrupt.
That's the bylaws, section 5.01 of the bylaws.
Right, and I think there's
It's on the same.
a charter amendment that has the same language.
The two charter amendments are, I'll disregard the reference. There shall be no preference, limitations, or restrictions with respect to the relative rights of the members. Notwithstanding, and for clarification purposes added, notwithstanding and for clarification purposes, the qualifications for candidates and election to the board of directors and for service on the board of directors are separate from the rights of members. That's a necessary thing to put in all of these
Right.
qualifications about felonies and familial and so
Right.
forth. That's one. The next one is in addition to a separate paragraph, separate article actually, the qualifications for candidacy, election, and service on the board of directors shall be as provided in the bylaws. So neither
Right.
one of these refer to a non-eligibility to a current employee. The
Okay,
only reference in the bylaws is to can't be an employee and a board member at the same time.
right. And I understand that. What I'm saying is committee included a ban on employment as an eligibility criteria. And I don't think the board ever picked that up. So it's not in this package of board resolutions subject to the upcoming public.
Referendum.
Yeah,
Yeah, Steve,
yes,
I did put forth a motion. Let's see. Nope, it's not there. I thought that was an employee. I think that we missed that one.
okay.
Okay, so I will take a look and see. Let me see what this one says. I don't see it in the packet of motions that we acted upon in the special meeting.
Okay, well,
So,
I don't think it's
so it
anything.
looks like we need to make sure it's in here. But, so I will, here it is. Yeah, there is a motion here that I put forth that says no member shall be a candidate for election as a director if he or she is an employee of the association. That was 502A4.
Right,
So let me go back to the 502 here. So we had 3. So let me. Okay, let's see. Looks like it didn't make it in here.
it didn't make it into the packet, but the board had approved it.
Didn't make it into the packet for the meeting on February 7th, the special meeting
Okay, I got
for
it.
consideration.
All right,
So I'm gonna have, I don't know, let me see what Doug put in his summary document that he sent out. It may be in there. Let me see if I can find that, or that we sent out. So that would be referendum. Okay, summary. Nope, didn't make it.
okay.
So let me bring that to the board's attention and see if there's something we can do about it at this point.
Okay, thank you.
Okay, let me add this to my list here.
Okay, Josh, can you bring up resolution M09?
Yes.
There's actually a change on page 1 that we could look at. Why can you scroll a little bit? Hold it. At the very top, in B, there's an addition to the current resolution underlined there. The president will also appoint a committee member to serve as chair of the committee. That's actually was not included in the original resolution M09, but it, at least for consistency or clarification purposes, the president, in addition to having a committee appointed, the president also has to appoint a chair, right? I don't think anybody.
We added that in
Yeah.
at the meeting. Yeah.
I don't think probably not any reason to hesitate on that one. There's no changes I see on page 2. And the next place where our changes are on page 3, and it's in paragraph 8A. You just scroll a little bit further.
AI.
Yeah, AI. I'm sorry, AI. There's one sentence start out in I, and then the remainder, the secretary shall use, is an addition. Now here again, we have the State Department of Assessments and Taxation reference.
Yeah, you gotta take that out.
Okay. So it would read, the secretary shall use the Worcester County land records to verify property ownership.
Yep.
That would be our recommendation. Colette, do we need to send you our comments, or are you following along with?
This one I'm not following, so tell me what this one is.
Page 3, 8AI.
Okay. Oh, that's in the candidate verification? No, MO,
Yeah.
whatever.
Right.
Yeah, let me grab that.
You're recommending
Going
to
back
cut
and
what's in
forth. I'm
blue,
trying not
correct?
to have my husband have to listen to this whole meeting, so I'm trying to do this in a private part of the house. Just a sec.
I have the same problem.
I think the
Okay.
rest of my family just tunes me out, so there's no problem. They're used to me having meetings, so.
Okay, at the bottom of that page is in IV. It's just not a correction, but to apply, to use the correct form, candidate registration form. I don't remember what it had there before, but candidate registration form is the proper form, proper designation to be used. That's all that is. And then I think we're ready to go to the next page. At the very top, well, you can scroll down to let this stop right there for the time being. At the top, it says as has and has the underlined, whoops. Okay, I have printed mine in not a different format. I've got mine on different pages. I kind of eliminated some stuff. IV
Okay.
goes on to say that the applicant has provided the attachments required by the candidate registration form. That's a responsibility of the secretary to make sure that the candidate has provided all the necessary attachments. That's just an additional comment on what the secretary is supposed to be doing.
So you're small v, 8A small v. We've gone past 8A IV, correct?
Yes, we're ready now for V, small v.
Right, I'm with you. Okay.
Okay, I'll just briefly make my summary of this. It's to start off with other comments. This gives the secretary a fairly extensive discretion to interact with the applicant to obtain additional information, correct information. I think that's actually to say that, and additional time to submit information where there may be some reason to do so. I think it's, at least I'm going to suggest this is in the discretion of the secretary. Now, again, I want to back out right now and make sure everybody has their own opportunity to comment on this. And if you need to read through what it says and haven't before now, go ahead and do that. And this is an expansion of the secretary's authority in the review process of an application. Let me just leave it at that.
You're saying it's an expansion because the secretary has the right to grant an extension of time.
That's correct. And in particular, that's correct.
Well, I mean, again, as I recall our previous discussions, it has been the view of the committee that the burden rests on the candidate. And if the candidate hasn't met his burden, you know, the chickens come home to roost. I mean, I would have some concern about the secretary having the authority to grant an extension of time. They already have, what is it, 2 weeks or 2.5 weeks between the time the applications are given to the secretary and the time she has to certify them, right?
Yeah, at the current time, it's 15 days from the
15
15th of May to the end of 1st of June. If the bylaws provision that applies is approved, it would be from the 10th to the 1st, so it'd be an additional, basically pretty close to 3 weeks.
So
Yeah.
what would the extension, unless I'm just not realizing, but would they utilize that extension for just one candidate that they're giving time to rectify or clarify any questions that the secretary has about their application? Or would that extension apply then in all fairness to all of the candidates then? Because then I think that plays a tricky role in somebody saying, well, you gave them more time to expand upon their qualifications or whatever, and I didn't, and I thought of adding something, but I missed the deadline. Is the extension pertaining to the secretary clarifying questions? But if we said, they've already got a good amount of time to already built in to ask those questions and get a response within the original timeline, right? Correct?
Yeah, I don't know that I can give a very good answer, but what was articulated at the meeting in which this draft was considered, the board meeting, was the possibility with all the information that we seem to be headed toward a candidate having to be able to provide, depending on their circumstances, having to provide, it may be difficult for the candidate to gather all of that information before the due date, which would be May 10th or May 15th, depending. And it's an inarticulated concern that there may be such a circumstance. No specific, I don't recall any specific examples were given, but we now have the potential for there being information having to be provided regarding a past felony conviction, however likelihood that may be, but a past felony conviction. Maybe there is some kind of trust property issue that has to be somehow information has to be obtained regarding that. A life estate issue, something along those lines, or whatever the case may be. The concern is, well, we may have a candidate who has to provide some information here and can't get it from wherever he has to or she has to get it in time for the May 10th, May 15th, whatever date. That is my best articulation of what's behind the extension.
Can I make two observations? Sure. One is, as I say, our committee's view has always been the burden rests on the candidate. And of course, we're measuring the date from the date submitted. In other words, candidate had the application form sometime in advance and knew or should have known what was required in order to complete the application correctly. That's the first issue. The second issue is actually three, but the second issue is also there is a gap of time by which the secretary and the candidate can interact to correct that issue, whatever it may be. And the third one is the one that Laura points out, which is you have the potential for two candidates being treated differently during the same election cycle with this language, because it grants discretion to the secretary. I would almost guarantee you is a again, as to where the committee's position is in the past and the potential for shenanigans being played in the future, I would think you'd want to strike that provision.
Well, my question would be, if you really want to run for the board, you know, probably 6 months in advance, you're going to run.
Correct.
And you can begin to collect the data. You have all kinds of time to do it. The
Yep.
disadvantage right now for this upcoming election is the application form isn't available. So
Right.
that's going to crunch the window and not give them 2 or 3 months to prepare.
Yep.
But I think the burden belongs on the candidate to get the information ready and have it submitted well in advance. So it can be looked at and you can get back if there's a question. But I agree. The committee has taken the position the burden of proof should be with the candidate of providing the information.
And that's one of the reasons why we wanted to look at and revamped the actual application to include clearly more of that information that ended up being questions later, you know, putting full legal name, not what you go by, you know what I mean? Or what matches on your trust or your deed or whatever, so that you have all of that information. And as Bob said, that's our hindrance for this upcoming next election, is that that's not been finalized and approved.
Yeah, that puts all candidates at a disadvantage because they don't know what's required and they can't do the research to get it.
Okay, can I correctly say that we do not support the provision that provides for an extension of
Yes.
extending the time to submit an application?
Yes.
We do, as a committee, we do not support that, where it says, whatever it says here.
But the secretary should not have the discretion.
Right.
Yeah, let me,
I mean, if we have no candidates, then maybe that is an opportunity for the secretary to recommend to the board that we extend this whole process because we don't have the, you know, candidates or something like that in that extreme kind of situation. But as the others have pointed out, you know, once we make public the application, they have time to get it completed, and the majority of that burden should be on the candidate, knowing the expectations of the position, you know, the time commitment, all those kind of things. If we give them all that information, then they really know if they want to submit it fully and to be considered and go through the whole election process, you know?
And if they have that information, they can then ask questions of the secretary if they don't understand prior to the deadline of turning it in.
okay, we'll try to make sure we're in agreement on one particular thing. The party in the provision where it says the secretary can determine if an extension to the due date is warranted, and it goes up above that. There's a description perhaps of the kinds of circumstances in which the secretary would be making that decision. Can we say that we do not support the secretary being able to extend a due date?
Yes.
Yeah.
Yes.
For me, yes.
And the considerations that would go into the the secretary, the foregoing before that talks about information and what's available and so forth, and that's not very good description. But it gets into the circumstances that would lead the secretary to grant an extension. We don't support anything related to extending the due date of an application. Is that a fair statement?
All right, correct.
Yeah.
Okay.
Yeah. I think what you have is, if you read small v, secretary contact each applicant to confirm a candidate registration form has been completed correctly. In the case where the form has not been completed correctly, the secretary will identify the information needed and contact the application to have them provide the required information. The secretary will remind the applicant of the due date for providing the required information, period. And then
I've already given them one
drop
reminder.
the rest of it.
Right. How many because the way I'm taking Steve's comment is, right there, you've already stated the secretary has contacted the applicant, asked questions, told them when they need to get that information back to the secretary by. Then as it's getting closer, the secretary reminds them, that applicant, of the due date if they haven't heard from them at that point, and that should be it. How many more reminders do you give them?
Yeah, I mean, and that makes it clear where the burden rests.
Right. The only exception would be what happens on the due date if you have 2 vacancies and no candidates. Then
Well,
a board has to do something.
Well,
Yeah. That's not addressed in this provision, so.
I understand.
Right.
Yeah.
That's addressed in the bylaws.
yeah.
Okay. And I missed that part. Yes, I agree with it.
That's
Isn't it right there?
bylaws section 502E, additional candidates.
My feeling is we need to be careful about giving subjective decision-making power to any one particular board person, whether it's secretary or whoever, because that opens a whole nother can of worms. If somebody doesn't, because it's subjective, we could all potentially have a different viewpoint on why that decision should or should not have been made. And I think it puts less stress or risk of having no one ever wanting to be secretary, because
Yeah,
you're going to put so much responsibility, and if everything goes to cahoots or whatever you want to call it, and that one person is totally responsible, and are they going to be the only person sued then because the board didn't have I just think we should limit the subjective
I
opportunity.
agree.
Okay, let me get back specifically to another earlier part in this. In the case where the form has not been completed correctly, the secretary will identify the information needed and contact the applicant to have them provide the required information.
Period.
Period, yeah. Is that a provision that we all support?
Yes,
Not that we all support, that the committee supports.
yes.
Yes.
As
Yeah.
yeah.
And then you can pick up the next sentence after the crossout. The secretary will remind the applicant of the due date for providing the required information, period. At that point, I would delete the rest of it. That would be my recommendation.
Okay, yeah, but what happens if the secretary is unaware that the application is incomplete after the 15th or the 10th, whichever?
Well, that's-
Somebody comes in with an application on the 14th or the 15th or the 9th or the 10th.
then that should be one that they look at immediately,
Well,
not waiting till,
Still have to June the 1st to certify the application.
yeah,
It's a candidate that has a head start for next year's election.
yeah,
Yep. Mhm.
yeah,
It doesn't exclude them from running in the next
No.
one, correct?
no,
I mean, the burden should be on the candidate,
that's
not
my
on the
feeling.
secretary.
Now, I have no problem with an applicant or potential applicant, as the case may be, communicating with the committee regarding what these requirements are or what they have to really do to meet these requirements. I don't have any problem with that. The secretaries may not be very pleased with me saying that. I understand that, but I don't have a problem with a potential applicant determining what they can or cannot, not what they can or cannot do, but what is or is not required. For example, this is not a direct example, obviously, but there's a gentleman at the board meeting the other day that was concerned about one of the provisions going into eligibility to be a candidate, and would something in his past make him ineligible to be a candidate? Well, he's ahead of the game as far as becoming a candidate. That's beside the point. That's an individual who potentially would be a candidate or an applicant coming forward and asking, hey, what does this mean? Can I or can I not? I don't have a problem with that. But once you hit that 15th date, I gotta draw a hard line.
Yeah.
That's my view.
Yes, I would agree that the applications need to still be in by the certain amount of time, you know, to get that done. But that's also his concern, that resident's concern would also be another reason why we want to make sure that the application itself is clear as can be, asking any, for any information. And like the past legal records or things like that, you are, may not necessarily preclude somebody from actually being a director, but it's information that should be left up to us as individual residents who vote to determine if it affects whether or not we feel that person is someone we want to vote for. You know what I mean? So it's back to, again, making sure the application is complete and we're asking all the correct information that we need or potentially feel that we could need from them to fill out there. And then it's up to the residents to decide if they are considered an eligible candidate and it goes forward. Then it's up to the residents to look at that application and decide what information that person provided to all of us, if it makes them want to vote for them or not. That's on them.
Okay, I certainly agree about the application needs to be comprehensive and clear. But what we're really talking about here is what I hate to say latitude or discretion, but what I think we've already decided that we're not going to we don't support giving the secretary the authorization to extend a deadline.
Okay, so can I take that to the board then? That's a consensus decision you've made.
Yeah.
I've written down your rationale. I think I can explain it clearly to the board.
I think that part of it, certainly you can. Again, I don't want to differ from someone else, but that's my understanding that we do not support the extension part.
Yes,
Well,
that's what I'm hearing also.
Okay.
Yeah.
So were there any other changes to this that you had discussed that I missed?
Well, I guess we were discussing how much interaction, these are my words, interaction there can be between the secretary and the applicant regarding the content of the application. Whether the content.
And what I heard was a question about the secretary identifying information needed. And I think that's a slippery slope too, when you talk about discretion.
Okay.
But is that what you're referring to?
Yes, I believe so. Let me make sure I'm looking at what I'm looking at. Well, the issue becomes, can the secretary see a deficiency and have the applicant correct the deficiency? And I have difficulty saying it any other way, and I have difficulty putting together an example of what I'm talking about.
Well,
Yeah, but
I'm sorry, go ahead, Colette. I didn't
I
mean
was
to.
just going to say in the board discussion on this, it seemed that the idea was that, yeah, if there was a deficiency, I guess, in terms of needing clarification or additional documentation, that the secretary may interact with the applicant. And as a witness on the stand in the Farr versus OPA case, the judge asked me about that, about the secretary's interaction. You know, do we ask the application, the applicant, you know, and my answer was, you know, the burden is on the applicant. I did not feel comfortable asking for more information in the absence of the authority